a special understanding.
We also like smiles, right? But they didn't smile for us. I'm just saying.
Okay,
like smiles.
So this morning there are going to be a few ground rules over here, gentlemen. Good morning. I hope you're well.
Solomon, very well.
Very well.
They are for you.
You're very, very well.
Yes.
It's rather strange that you're very far from me today. I don't know who planted you there, but I hope that you're well. Yeah, I hope that you're well.
It should be investigated.
It should be investigated, eh? And while you are sitting right by Kamal as well. Kamal, I hope you're doing well. Mr. Owusu, I hope you're well.
I'm good.
Dr. Joshua, I hope you're well.
Thank you.
So Dr. Joshua earlier said that he nearly became a Reverend Father and he would have been addressed Reverend Father Joshua.
I attended a junior seminary. Yeah.
Okay.
So there St. Francis Xavier Junior Seminary. I should have gone to St. Victor's. I now Rabbi Holy Father.
You would have been okay.
So when you see me, know that was almost okay. It's okay.
Okay.
Maybe some characteristics in you did not allow you.
Okay.
Kamal, you're my brother. The way you started, no? That should have been coming from Hamza or Solomon.
All right, guys.
You are mischief people. No, you.
Okay. Okay. So a lot has been happening, and this morning a few matters arising. We shall touch on the minority slamming judiciary and asking whether or not judges are serving their paymasters. And the minority leader led that press conference yesterday. And as well, Martin Pebu versus the special prosecutor. They're in the news. 2 days ago, him together with another pastor as well petitioned the removal of the OSP. And the question about Zipline as to whether it will have a major impact on our health sector, especially in delivering of very essential health needs in hospitals in the rural communities. We'll look at that as well. As well, the coup in Guinea-Bissau, of course, implications for political stability in the West Africa. I'll start with you, Hamza. Let's talk about the judiciary. And this is coming at the back of the Kpandai constituency. So is Kpandai close to where you come from, Hamza? Is
it depends on how you want to define closeness.
Okay.
In any case, good morning to you. Good morning to my colleagues in the studio and your production team, as well as our cherished viewers out there. MFA, Kpandai is part of the northern region of Ghana, and that's why I said that it depends on where you're coming from, because if you want to use the eastern corridor as well, you can arguably say that Kpandai is also close to the Volta region.
In fact, it's part of the 18 constituencies.
Absolutely. So it's part of the 18 constituencies in the northern region. So yes, after Yendi, then you move towards the Kpandai area. We call those areas, is it the Eastern Corridor?
Eastern Corridor.
Right, so precisely. But you see, it is not just about the identity of Kpandai. It is about the 1992 Constitution and our electoral laws. As a people, when we promulgated the 1992 Constitution, we all made a commitment to honor the principles inherent in that particular document and conduct our affairs in ways that are reflective of those principles. I don't think that it has changed since we adopted the 1992 Constitution. And per Article 99 of the said Constitution, after every parliamentary elections, you are given the legal impetus to challenge same if you feel strongly about the way that particular elections were conducted. I understand that the NDC parliamentary candidate decided to invoke his right under the 1992 Constitution, specifically Article 99, to challenge the outcome of the Kpandai elections because he was convinced, and still is, that certain things were done, including the relocation of the coalition center, that clearly was not in compliance with the electoral laws of our country. Where best is such a person suited to go for redress, if not our law courts? And per our Constitution, the appropriate forum is the High Court. If you are not satisfied with the outcome, then you have your right of appeal to the Court of Appeal, which becomes the highest court in relation to election disputes at the parliamentary level. That has been carefully decided by our superior courts of judicature. So, MFA, these are the facts. Now, This is not the first time under the 1992 Constitution, and since Ghana adopted this form of Republican democracy and Constitution, that we have had people challenging the outcome of parliamentary election results. And it is important for that point to be made. I remember somewhere in 1997, the NP elect for the Ayawaso West Wagon constituency in Greater Accra had his election challenged by the MPP candidate, Honorable Isaac Amu. Indeed, the High Court at the time, in strict compliance with Article 99 of the 1992 Constitution, declared that election results declaration null and void.
Did it take the Member of Parliament out of Parliament immediately? Did it take effect?
Yes, it did. No, subsequently it did, but not immediately.
Okay.
It was later. Because the MP challenged, just like the Kpandai MP has done. He also appealed to the Court of Appeal and proceeded to also request for a stay of execution of that particular judgment of the High Court. But subsequently, he was not successful. So that was not the first time. Mind you, we are talking about a time in history where Rawlings was president of the Republic of Ghana. We are talking about a time in history where that was the first election the NPP decided to participate. Remember, they boycotted the 92 parliamentary elections.
Yeah.
Yet still, they went to court at the back of the 1992 Constitution and won a case against the sitting NDC MP then and the sitting government, the NDC party then, with Rawlings as president of the Republic of Ghana. At the time they said that our institutions were not working appropriately, they invoked the jurisdiction of the courts and they were given justice. The NDC did not cry out by lashing out on the judiciary, calling them shameless, calling them paymasters. We did not do that.
In Parliament yesterday, and I'm staying with you a little longer because you're a lawyer. Let's just do some learning this morning. Yesterday, I
would allow me to end my submission on this.
Okay, I wanted to go to the second point.
Oh, but
Same issue?
It's on the same issue.
Okay, yeah.
Is this on the same issue, on the Kpandai constituency issue? And when you're answering, you can box it together, but it's on the same issue on that seat. In Parliament, before Parliament yesterday, actually, I had a conversation with the Member of Parliament whose seat, I don't know whether to use contention or, well, we're discussing Nyindam, who said that, well, he's still the Member of Parliament for that constituency. Out of the politics, I want to stay in the law. Where yesterday in Parliament, Afenyo-Markin said that he cannot be allowed to engage in debate. Yesterday was the final debate on the 2026 budget, and that he cannot continue to hold himself as Member of Parliament, and that filing an order of stay of execution does not cushion him to still be in Parliament. Legally, is this right?
I think I agree with that proposition by the Honorable Roxanne Afenyo-Markin. But that is my view too.
Okay.
Because filing a stay of execution or appealing a process does not operate as an automatic injunction on the earlier decision or stay on the earlier decision of the High Court. That is the position I hold. It is possible that judges would disagree, but that is the legal position I hold on this matter.
Okay.
But you see, MFR, to the substantive issue. Look, apart from the West Wagon incident, we've had a similar situation in the past. Is it Akwitia? Where the High Court again proceeded to annul certain polling stations when Baba Jamal and the likes went to court.
Yeah.
This country didn't calm down. So yesterday, I was disappointed, scandalized, listening to the minority leader, who himself is a seasoned lawyer and practitioner, to have demonstrated such boisterousness and parliamentary conduct, dishonorable, to say the least, of a member of parliament, with such open attacks on the very judiciary not long ago. He was appearing before and calling the NDC to come and respect that institution. Remember, when the NDC had issues with the decision of the Supreme Court to sit on the declaration of the Speaker that certain parliamentary seats had become vacant.
Yeah, the cross-carpeting
Absolutely.
position.
MFA, this same gentleman who now doubles as the minority leader had an unprecedented access and attention in our superior court. In a matter of 2 hours, he got a full bench of the superior court to convene. That has never happened anywhere in West Africa, let alone Ghana. He had that luxury of preference. Did the NDC use such unprintable language on the judiciary, even though we had our concerns? We did not. Okay. You refer to the judiciary as paymasters. Since when did they become paymasters?
They're only asking a question. Are they?
No, it was not a question. He said they were dancing to the tunes of their paymasters. A categorical statement made. And you see, I have always said that as a country, we have to be careful with the likes of Afenyo-Markin. I have followed his politics. And it begs the question whether indeed even the MPP as a political party is actually ready for reform, especially after their humiliating defeat in the last election. Because if you look at the front bench of that house and what he's subjecting that bench to, the NPP ought to be concerned. First, about his own international image and their own local internal politics. Because we have seen minority leaders in this country. We have seen how they have conducted themselves. But on a daily basis, we wake up to the politics of Afenyo-Markin and we are reminded of how we used to play student politics at the Solo Nooks level. So the gentleman has simply failed to transition. And he's not just a threat to the MPP as a political party, he is also a threat to stability as far as our parliament is concerned. Okay. Because that conduct, if it is coming from a first-time MP...
Before we open it up to the judiciary as a bigger conversation, I just want to also take the other's take on that.
No, but let me...
And as to particularly...
Under a minute.
Today you made me a promise.
Yeah, under a minute. Under a minute.
Today you made me a promise.
Under a minute, because this is important.
Okay, see, so land on it.
These are people who are mandated to protect judicial independence, and not just the judiciary, many other state institutions. We saw his conduct even when the current Chief Justice was being vetted. We took it for granted. We saw how the same Afenyo-Markin attacked a clerk of parliament and accused her of bias. We swept it under the carpet. We saw how he assaulted a police officer for doing his work. Are we trying to send a signal that this gentleman is bigger than the 1992 Constitution and the laws of Ghana? And that is why I am waiting for the Attorney General to take a decision on the docket that they have before him, before them, especially as regards the assault case against him. Because when I was listening to him yesterday, I saw his pretense.
He spoke on behalf of the minority.
Yes, so but when I was listening, and that is why the MPP needs to be careful. Because listening to him, I could see the strategy behind his outburst. It was simply intended to preempt the likely case that is likely to come against him. Because he knows that if he goes to court tomorrow and he's found guilty and sentenced, even for 6 months, he loses that seat. A by-election will be looming in his constituency. So he's preparing the grounds
Hamza,
to protect himself, not the Kpandai MP.
Let me stay on the Kpandai constituency seat first. Kamal, so I saw that you're nodding your head.
Thank you very much.
Again, when I come back to the lawyer, what I'm interested in the past, he tells me that when it happened in Ayawaso West, subsequently, the person then couldn't hold himself as an NP. But this particular one, I mean, I read about it those times. I was quite a young person.
Deal with it,
okay, so let me know whether...
Sometimes you don't just need lawyers. We are here for discussions, basically. Lawyers show their prowess in courts before the bench, basically. But here, you don't assume someone is a lawyer and therefore...
I'm not assuming he is, so...
Well, I'm just trying to caution for us to have a decent discourse this morning.
And he's correcting you. She's not making an assumption.
Thank you very much. You see,
you are a lawyer.
I'm not disputing that you are a lawyer. No, you are a lawyer. You are a serious lawyer, and I know about that. So that one is okay. But of course, when it comes to this table, we need to espouse common sense and espouse knowledge as well. First of all, what the minority leader did yesterday was to vent on the trend that is presenting us with a dangerous, if you like, outcome, if we are not careful, about our judiciary, which should be a concern to all of us. I have always referred to lawyers as men of God, and I've always referred to judges as lords. Because when I am seeking remedy as a citizen of this country, the only place, forum, that I can confidently go to get that remedy and believe justice is served is the courts of Ghana, which the Constitution per Article 125 says so, that justice emanates from the people and, of course, shall be served and administered by the judges on behalf of the people of Ghana, which is clear. Now, why did the minority leader have to come out, or why did the minority leader come out this way? Like I said, the trend. We are in this country, when judges were referred to as unanimous FC by them, Supreme Court, Apex Court judges will sit down and on point of law issue judgments. These people will come out and call them unanimous FC. In this country, Getu Chokono, justice, was referred to as MPP women organizer. We have removed the MPP women organizer. And we all know the way.
By which people?
With all respect, please. I was very quiet. You see, I was very quiet. We are
talking about a minority leader.
It's not just for lawyers. It's for us to have a discussion.
Allow him.
We are talking about a minority leader.
Please. Hamza, make your notes.
Hamza, just have
please allow him.
You have time.
Kamal.
In this country, a chief justice removed under Article 146, which is supposed to be done in tandem with Article 296 on discretionary matter or discretionary matters. We all saw what happened. Legal luminaries had to advance arguments, listen to the latest, judgment by the African courts. What did he say? So the substantive matter was not attacked. It was procedural that was attacked. It means that it leaves a dent. So what the minority leader is saying is that, look, the trend that we are faced with, if we are not careful, we will end up having a judiciary that we will not all have confidence in it.
Will it be the same judiciary that sat on the many cases that the MPP took to court?
That is the point. So you see, I have cited the NDC chastising the judiciary. They are citing the MPP chastising the judiciary. And I started off by saying that the only forum we can all seek remedy is the judiciary.
Yes.
You understand? Therefore, whatever we are doing as political actors in this country, we must be mindful of the fact that that forum, that area, even if there's a coup d'etat, do you know Guinea-Bissau, what has just happened? Judiciary will not be attacked. Usually, he knows it. Judiciary is left like that. When Rawlings did the coup d'etat, judiciary was not attached.
But if you know this, why...
So I'm trying to say that the judiciary, the sanctity of it must be preserved by all of us. We owe it a duty as political actors to do that. So the minority leader, looking at what is happening, first of all, before the election 2024, John Dramani Mahama, our president today, His Excellency, had cause to say that they believe that the courts of Ghana today is filled with MPP judges, and therefore NDC judges will be there, should also be there for a balance.
But the case in point, this judge is not a new judge. He's not part of the reset that the NDC.
I've not said so. We are talking about judiciary. We are not singling out a judge.
We've got to make it the case in point.
Well, you see, when lawyers speak to judgments, they read maybe when the judgment is actually out or the process.
We are not talking law here. You said those.
I'm not talking law.
So don't go there.
They look at what the loopholes are, how it went, what were the proceedings. Outcomes sometimes are predictable based on point of loss, as it were. And the minority leader said, look, we have led evidence to this regard. The person who we are talking of here, the witness who said there was problem in Kpandai election, said that there were only problems in 41 polling stations. 41 polling stations. Close to over 500 or something votes, we are told. Now, out of that, the same person who won, the MPP candidate, won with some 3,700 and something votes. Granted, it's even what the case is, that the 500 votes were out of it. We still have some 3,100 and something votes. On the face of it, every reasonable mind will tell you that there was a case actually for the MP for Kpandai.
If I, granted, if I come with
I am saying, but however, the judge then, based on somebody who I came to you.
Come along with me.
Wait a minute, let me just allow on this. When the judge says that.
So here's my question, though. Here's my question. Don't get agitated.
Okay.
So the nuances that you're presenting on the table today is not what I'm debating. I'm asking about the process, but there are remedies available to you. If you think that the judge who sat on this particular case didn't do you any good, it wasn't your day in court, you have started the process, you filed a stay of execution.
Right. Hamza sitting here, my good brother sitting here, had cause to take a judge to the cleaners on his Facebook wall. When the judge cited Animal Farm, he had cause to write about that judge that no, this legal taking was wobbling.
Okay,
you understand? I'm saying,
but not procedural.
I am making the point here.
But not the
so
process.
that means that when there's a judgment that is weak, when there's a judgment, when there's a judgment, I'm saying when the judgment, that's what lawyers attack judgment. When there's a judgment that is troubling, when there's a judgment that is not so good and not pointing well to our justice system, a lawyer of good standing who understands the law and who has gone through it says that no, I can actually attack the judgment, and the way things are going, I think we should be careful because our judiciary, if we are not careful, will be pushed to the dogs, and that will be a dangerous path for us.
Granted, so should the minority not be addressing and saying this after all the processes have been exhausted? For you to now put the judiciary, box it and say that, are people serving the paymasters? I don't know if you understand, because we have not closed the process.
Before, during, or after.
Okay.
You reserve the right, if you have an interest in a matter, which matter is not actually, in your view, going accordingly the way the law says it should go, to actually raise fingers or to raise red flags on it.
Okay. But straight before I come to Solomon, so do you think that Nyendam should be in Parliament regardless?
Oh, no, you asked him a question about when he cited the Isaac Amu case, when Amu took Ayosu West were going to court. Amu was eventually declared the winner of the seat. However, Parliament had actually ended. The person who was wrongly elected said in Parliament, I'm not saying in this case that Kpandai MP is wrongly elected. When we take even the same person, Roxy Dafemako, he made the argument when Jasi Kwesin case came. Jasi Kwesin, Asin North.
Yes.
When Asin North case matter came up, and then the Cape Coast Court said no, he was not validly elected, they filed an appeal, and then filed stay of execution. Based on that, the firm of court came out to say, look, based on the services to the courts, waiting for the registrar to give us date, or if the date is given, for the court to pronounce on it, then of course nothing changes. He stays as an MP. You made that argument. And he himself corroborated with the Isaac Amu matter. It was later. So I am saying today, Kpandai MP, you have ruled, but we have filed a case of a stay of execution.
Yes.
We have also filed an appeal to that to move on. And pending those pronouncements, it is our argument that he stays as an MP and then the processes will move on.
Okay, I'm coming to Solomon. When I come to you, Hamza, my question will be precedence. What has been the precedence? Because this is one of the pertinent places we can go to check, right? So when I come to you, but Solomon, what's your take on this? Should he hold himself as a member of parliament for Kpandai or not?
I mean, whether or not he is a member of parliament, the ruling of the court stands. The court says that there has to be a rerun. And if there is going to be a rerun in a particular constituency, then you cannot be a member of parliament. You see, the mere fact that you have filed a stay, there are these two arguments. Notice of an injunction is as good as an injunction, but it has been proven. Remember the case of the e-levy. When the e-levy was, the bill was sent to the president to assent, a citizen of this country went to court to file a stay. The president said that didn't bar him from executing the mandate. It was signed, and then we started paying the e-levy. So we must be consistent. I think it's one of the areas that the Supreme Court must make a pronouncement, a bold one on it, so that we know that a stay of execution, the mere fact that you have filed, does not constitute an injunction. Then all of it can move on.
Two sticking points.
Yes.
Stay of execution has been filed.
Yes.
Plus, the court has held that there should be a rerun.
Yes.
So, can the NDC decide to want to go? Because if you have filed a stay of execution, we don't have any decision of the court on that stay of execution.
No, there is no decision on that stay. But there is a decision of the court.
Of the court.
Of the higher court. So that is why it's operating.
So that one
is operating.
Is it automatic? Does it take
No,
effect?
from where I sit, it means that you have to prepare. And it is the reason why when you go to Kpandai today, both parties are campaigning. Because that is the decision of the court.
Okay.
You understand?
Yeah.
And there hasn't been any pronouncement apart from what the High Court has given, for which reason you must abide.
The Member of Parliament says that, of course, he's law-abiding. He's going to adhere to it. There's no issue with the decision. They'll go through the process. But until that, yesterday, he had a role to play in Parliament, and the majority refused him. So I'm asking, between the time this rerun is held, between the time a new MP is declared or same person is reconfirmed, who is the Member of Parliament at that time?
For now, that
seat is vacant?
supposed to be vacant from where I sit. It's supposed to be vacant because, you see, the decision of the court was so clear, and the press conference by the minority even confirms that the seat is vacant. What were they doing? They were complaining about the rule of the High Court to the extent that they were even bastardizing the judiciary. If in their mind the state was working, why would they come and do that? In any case, all the things that they came to enumerate, tell the people of this country, that is what they are supposed to go to court and back their candidate with. What they did, we are not court. If you have any evidence, if you have any information that will help your Member of Parliament's case in court, you help him with it. In any case, Afenyo himself is a lawyer. But you see, let's come back to them. Don't let us even digress. Look, this country, we are making a lot of people heroes when they are not heroes. One of such people is Afenyo-Markin. And I'm very surprised that Kamal will not look straight into the face of Afenyo and say, you are destroying their party.
So you don't tell me what to say. Just go ahead. And
I am so sad.
Don't tell me what to say. You don't decide for my party. Just
last year.
He doesn't decide for our party, please.
Just last year, we were in this country. Afenyo was the only Ghanaian in history to have been able to cause the Supreme Court of this country to empanel on Friday.
Are you not the one making him a hero? Because the whole Supreme Court would have taken the decision by themselves.
No, I'm coming
How
there.
can you be the one?
No, I'm coming. You see, when you allow, you would understand it. You understand? It has never happened in our history. He went to court 12 o'clock. By 3 o'clock, there was a decision for him. At that time, he did not organize this press conference to come and tell us that the paymasters were working. In any case, you remember the case of the Obuasi East this year?
Yes.
You know, Obuasi East, the EC had originally declared the NDC, the late Abuaji, as the winner of that elections. It went to court. The same court that he's saying they are working for their paymasters said no, Abuaji didn't win the elections, but rather Buachi won. So they gave it to the MPP. I did not hear Kamal and Afenyo organize a press conference and say that they are paying, they are working for their paymasters. Besides that, you remember the case of annulled? At Insawam, they went to court. The court affirmed as annulled position that indeed he won the elections. We did not hear Afenyo bastardize the judiciary. So on what basis? In any case, he is telling us that he has not seen the full details of the ruling. So on what basis was he making those allegations that took place yesterday? It means he himself wants to make a hero out of nothing. You are leading the political party into abyss. Indeed, they are in abyss.
They don't believe so. Kamal doesn't think that he's leading. If they think he's doing his job fine,
he can deny by
his wildest
outside gentility, home cry. Outside gentility, home cry. That's what has been happening.
Okay.
But the truth of the matter is that any civilized person, our elections are governed by laws. Remember, election 2024 was governed by CI 127. Is that not the case? Plus the constitution of the land. If anybody has an issue with an election, parliamentary election, the person is supposed to go to what? The higher court, which the affected candidate did. The matter traveled. Each one presented their facts. At the end of the day, I wasn't in court. The judge says, looking at the facts, there has to be a rerun. I thought if there is any challenge to it, it is the appeals court that will go and challenge, which a stay has been filed. Go there with additional evidence to convince the judiciary. The very judiciary you are bastardizing, the appeals court is part of it. It means they themselves know the truth. They have already given up. They just want to throw dust into the eyes of the people of this country. Okay. Now you were told, no, you cannot be doing debit and credit here. I have sat here, listening to them. They were doing 10 minutes, 20 minutes. And I will be shocked.
How many minutes is the program itself?
No, you can do that.
How many minutes is the program itself?
Why? Do you feel your time is about to be taken?
Not myself.
No.
It will not happen.
To put him on notice. No, Mr. Owusu.
Yeah.
I was going to put him on notice.
Yes.
A few things you have said. When I get back to him, he will respond.
No, but you cannot be putting him on notice. When you were speaking, you didn't put me on notice. I feel this like...
Because I didn't say anything. I didn't say anything that
you want to prep his mind.
No, about what?
That you are going to put him on notice.
I need clarity.
Even himself...
No. I need to moderate the conversation for clarity. I need to moderate the conversation for clarity.
Yes.
I need to moderate the conversation for clarity.
I'm sure you issued a caveat before because of Solomon.
No, I didn't. I issued because...
We are here, you have brought your laptop with all your net files. You are reading from Azerbaijan to Ghana, and you want to put him on notice. Don't put anybody on notice here. So let's go.
Proceed.
So the plaintiff did what was right, went to court. The judge has given his ruling. We are waiting for the full details of the ruling for us all to peruse. So that if the judge errs, some of us will come and say, no, this is all right. But you see, even the accusation is not grounded in, it's not in the favor of the party that organized the press conference. First of all, this case started during the regime of the MPP. Is that not the case? At the time the case was taken to court, it was the MPP that was in power. It was under Justice Tokonu's regime that the case was listed. They assigned the case to a judge. On what basis is Afenyo and his people saying that the paymasters are the Tokonu regime or what?
This is the question I want to put him on notice to answer for me.
Now
would you ask?
No, I hadn't said.
You had said that. No, you had said that. You had said that in many forms.
I just made this statement.
You have said that. Let me
read into my memory.
No. It's not rocket science. This is just a conversation.
Yes.
So you have said that.
Yes.
It is the same minority at the time that were in power.
Yes.
The Obuasi East. You have made that reference.
Yes.
You have also told me about how Afenyo-Markin has been able, in the history of this country, has been able to empanel the whole Supreme Court and got judgment at 3 o'clock.
Yes.
So I'm about to ask him that your points that you have made, does he think that you have a valid point? In Sawome regime.
Yes.
Now we should add.
No, I said it.
So we should add it so that he would answer.
Yes, add it to it.
Okay. So that notice he didn't want me to put you on. You are not on that notice.
The one in court.
When he's done.
Where the judges doing the bidding of their paymasters, and in that situation, who were the paymasters? Were the paymasters the MPP?
Do you want a genuine answer to this?
I want. They have to be. And now are watching us based on what he himself has.
Now I have to bring him in to answer.
You see, the subject matter on the table has to do with whether judiciary.
No, you're supposed to be on notice. Notice. When I come to you, you answer it because that's has to.
All right.
Thank you. Good morning. If you just give me 1 minute, I want to talk about something that is very, very important and dear to thousands and thousands of people.
Okay, Dr. Kamal says good morning to all of you. She's doing the watching.
Yesterday, we got an email to UG staff, University of Ghana staff, telling us that our salaries have not come and they don't know when it will come.
Oh, is that so?
Yeah, it says that the planned payment for this month's salary has been impacted due to delays in the release of the government subvention funds. Government has not released funding for them to pay University of Ghana staff. And the University of Ghana is telling we, the poor proletates, poor workers, that they don't even know when the money will come. We've been told that the economy is doing very well. Ato is forcing. Please,
it's a matter of concern. It's very
please, Ato forcing.
This is the first
Come on,
time
let me use my time. Yeah.
But two MPP people are raising this good.
We see you.
He's a political
analyst. Ato forcing. We hear you are forcing. The salaries of poor university workers, and I'm not just talking about lecturers.
I've not read that email.
It's an official communication to the so it's not a secret. They blasted it.
Because I need to see the content.
No, the university sent it to us. And they're talking about poor workers. You can talk from the cleaners, the sweepers, all the way up to the vice chancellor.
Poor worker.
So even if you say Dr. Jabunte Zato is not a poor, but think about the sweepers, think about the cleaners, it's university staff. And you see, the funny thing is that they are even saying that they don't know when the money will come. And so if the economy is doing so well, inflation down, dollar rates down, for everything we have told in schools is now, it's forcing. salary.
But the email didn't categorically say that they don't know when they email.
Yeah.
They said they're working with.
They are working on it. So if they know, they will tell us. We are supposed to get paid at the end of the month. The month is ending. You say the money has not come.
Ended.
Today is what is today?
27th.
27th. Tomorrow is Friday.
Hasn't ended.
The month will end on Sunday.
It hasn't ended.
Okay, we have been told because we are saying.
No, let's have this conversation on Monday. If it's entered, your salary doesn't.
Madam, please let me. So please, I'm begging you after forcing our small salaries, then we can start shopping for Christmas. The children already listen. Our small salary, we are not talking about benefits. We are not talking about anything else. Just salary. We've went to grading papers, lectures, doing plenty.
Dr. Zato, usually, when does your salary come? What day?
Oh, but let me say by the end of the month. I'm just saying that the last day of the month. The last day of the month. The last day of the month is tomorrow. Okay, you want specifics. By this time, 3 days to payment to the end of the month, we get an email saying that salaries have been paid. Depending on your bank, you will get it.
You get an email from who?
The university. I'm telling you the normal practice. 3 days to the end of the month, at least, they will send an email saying that salaries have been sent to your banks. Depending upon your bank, you get it, right? So that's the email we're expecting yesterday.
Okay.
It has not come.
And because you have not gotten an email from your school saying that,
so it's abnormal.
You should expect your salaries. That means government has not paid.
The university has sent us an email saying that government has not sent their subventions.
Yeah.
So they cannot pay us. They've said that.
No, but that is that the month has
educators.
Okay, I'll educate you by reading the email.
Yes.
The university committee is hereby informed of an unavoidable delay in the payment of November salaries.
Okay.
2. The planned payment date for this month's salary has been impacted due to the delays in the release of government subvention funds. So, yes, government has not released funding. The university doesn't know when they can pay us. We don't know when we'll get our salaries. So I'm just begging, please, after force, release the money so that you can pay us more. That's what I'm saying.
Okay.
Thank you.
But it could also be on his daily basis. Yes, it's very important.
Very important. It's normal workers.
Take care of his case.
It's normal plurality.
It
has not happened before. It has never happened before since I joined the university. That you receive an email saying that subvention has not come for us.
And your salary has never delayed, eh?
No.
It's never happened, right?
It's never happened. I've never seen it.
Your salary has never delayed.
Our salaries, in fact, it has delayed this year. 1 month, was it in August?
No.
We received the salary in the next month.
No.
Since I went to university, we will get it within the same month.
Your salary has never delayed ever since.
We will get in the same month.
Right,
so I'm saying, I'm just praying.
Are you sure?
I'm praying.
That's why I'm
telling you what it is. I'm telling you that I'm actually saying.
Even when we're dealing with E-level salary, lecture salary, when we had to pass, when we're arguing to pass E-level,
again, it's delayed. In one of the salaries, in one of the months this year, we received it in the next month. It has never happened.
Okay.
What?
It's our fathers and uncles.
Yes, I don't want to tell you that.
So we're concerned.
This year, in one of the months, we received it the next month. It has never happened. Usually, you will receive it around 28th, 29th, at least within the month itself.
Yes.
In this year, it has happened. So I'm just saying, please.
Bread and butter is very important.
Whosoever is in charge of salaries for you,
pay you.
Just University of Ghana staff.
I don't know. I'm crying my own cry. This morning, I'm crying my own cry.
Okay.
My salary has not come.
Okay, I'm certain whoever is in charge is listening and watching.
Whoever is in charge, pay university staff.
Okay.
Okay? Thank you.
He has used all his time on that subject. So
it's a very important subject.
Very important
It's a very important subject.
And when you are forcing, you should.
I'm coming
he didn't use all the time. Yeah.
Now, I'm coming to this issue, the substantial issue that I was talking about.
I'm interested in what you say in that issue.
Look, I am afraid of something.
Today, you've been afraid of a lot of things.
Yes, that we are increasingly see people gaming the electoral system and trying to use violence and other means to game the system. There's a reason why most of if you look at a good number of the cases that Solomon listed and other people, the issues happen at the coalition centers. The question is why? They don't happen at the polling stations, and you know why? Because when the polling station finishes, you get your pink slip. You don't know what is happening at the other polling station, so you cannot go and disrupt anything. You could be winning there. Do you know why they all happen at the polling? Because they happen at the polling station. By the time the coalition is going, every candidate has got their pink slips. They already know their position. So if you are winning, you will storm a coalition center.
Exactly.
If you are losing, you will storm a coalition center. So watch very carefully. The people that storm coalition centers are mostly those that are losing.
Solid point.
And by the time they are doing that, they already have solid. Now, in this particular
case, exactly what happened in Kpandai.
Please, let me
solid point.
It is never true. What you are saying is never true.
In the case, in this particular case, Whenever you watch it, so that is the end of the. But now look, I've got, there's something here. I've got the actual suit that was filed.
Okay.
I've got the actual suit that was filed.
What were the issues that were in there?
Release. You can read the release. You can read them. They are release. Now I don't know. I've just had to go see. If you are seeking release,
this is not a law platform.
No, I'm just asking a very simple question. I don't know if you could educate me. If you are seeking relief,
my viewers like to learn something.
You start from the most important relief to the last, or you just list there anyhow. I just want to know.
No, it depends on your issue.
It depends on your issue.
It depends on your issues.
Okay, so in a normal common sense, I would assume that you will start with the most significant and important relief you want. Come put like a hierarchy of reliefs.
Everything on it is important.
I know. I'm just saying I would think that you do that. Now, I've seen the reliefs. From relief A to J. They all focus on one particular thing. 41 police stations. In fact, it's only after J or is it after H that they said that in the alternative that you don't give me 1, 2, 3, 4, 5, 6, and not all the.
So it's part of it.
I'm not
but
saying.
You have already.
I'm not saying. I'm asking a question. That means that for me, as a non-lawyer, from common sense, the people are saying that this is actually the problem we have. However, if you wouldn't give us the problem we have, declare the whole thing.
Annulment is also part of the problem.
I said it. And so it raises a very simple question. If the people themselves in their reliefs are so fixated on 41 police stations, if relief 1 to Z is just focused on 41 police stations, the total be 500 votes. Then a judge goes and throws out all the votes. For me, it's worrying as a student of political science. Because I want to believe that courts will always want to protect the votes. That is why you realize that all over the world, courts are hesitant to throw out votes. Because the idea is that when people line up and vote and cast their vote, it should matter. When people, hundreds or sometimes millions or thousands of people vote, it should matter. It shouldn't take one man to do it. So courts usually try to see, is even if there's poison, there's death in the water, is this so much that it has polluted all the votes? If it has not polluted all the votes, sometimes the courts then try to err on the side of the majority of the votes. Or they should try to be very surgical. Okay, we've seen, yes, there are infractions. But the infractions happen at Joy FM. So Relief D says
that a declaration that the non-compliance with Regulation 43 of the Public Elections Regulation 2020, the CI 127, which Solomon cited, affected the entire results of the parliamentary election held in the Kpandai constituency on the 7th of December, thereby rendering the said result as void.
So what did A say? What did A say?
Of course, A cited the 41.
What did B say?
Most of the
Thank you. That's the argument I was making. That most of the relief sought focus on the 41. I made that point.
But the point
there was almost most of the reliefs were focused on those 41 points. So the question then is that if you just go and take, so I was thinking that in common sense, the court could have decided that let's be surgical. If the focus is on this, almost every relief sort, if the focus is on just 41,
people will hear what you
let's be surgical. Because what I'm afraid of is going forward.
Okay.
People get
I'm not. We did some pro bono airtime.
What I am afraid of is people gaming the electoral process. What I'm afraid of is that they are voting, then people are gaming, looking at their polling stations. Okay, getting their pink sheets and quickly doing their own. They do their own addition calculation. Master, we are losing this. Let's storm the polling station. The question is that when does the decision to storm the polling station come? We should be careful at the court. Does it come when a candidate knows they are losing? Or because my argument is that the decision to storm a coalition center only comes when the candidate, because when you are winning, you won't storm a police station.
People would like to protect their votes anyway, if they're winning too. But my follow-up question for you is that do I hear you suggest as though when some issues are raised in court, you expect that the judge should look at the most popular one on the reliefs that are sought?
No.
Because if you look at that relief D that the judge is seeking, it seems to be so outstanding that 41 is just a minute in out of the 100.
So I'm saying that of all the relief sought, again, so I've just told you that if you look all the reliefs,
yes,
the dominant thing there.
I agree with you. So, if you look at that one relief, it says that irregularities of the entire. That one is so.
No. It says that if you don't, in the absence that you don't do that, there's another legal says that. But the bigger point is this: A, B, C.
It doesn't matter A, B, C. There's no order of preference, no order of importance.
You see that when they were talking, I didn't talk.
He was quiet. That's true, Solomon.
You said that
He was.
Now they would.
You're helping.
You're helping me. The bigger point is that when you do this, then people imagine that here. So it is the activities of just 541 police stations that has now led to what? You throwing away almost, if you look at the distance, 35,000, almost 60,000 votes. It's activities of 500 votes.
That's your argument. That's your argument.
So the bigger point is this: going forward, I hope that we don't seem to be rewarding what's the name? Violence.
Gaming, political
we don't seem to be rewarding people who decide that by the time I've collected all my pink sheets and I've seen that I'm losing, now let me run to the coalition center, disrupt the coalition center, the coalition center,
Yes,
and then hope that if I do that, it goes to court, because once something goes to court, I always believe that it's 50-50. Once it goes to court, it's a coin toss. Now, hoping that I can usurp the will of the people. People in Kpandai waited 4 years to vote. And on 7th December 2024, they went out. They stood in the line. They stood in the cold. They stood under the sun. They left their work. They left their home. They left everything. They stood there and they made their choice. And their choice was Matuninda. A court doesn't just look at all that sacrifice and throw it away.
Okay.
For me, when you do that, you are diminishing the whole democratic process. You are diminishing the whole polling process. And you are making me look like kings. Judges should decide who leads people. It's not fair.
Hamza, your question when I was going around the table would be that what are the precedents? I'm very curious whether it is even 1 hour. If the judge had even put a date for that rerun, say immediately, tomorrow, between the time that judgment was given and the day of that rerun, what happens to that seat? What's the precedence? What?
I think that the precedence was arguably canvassed for, even in the last parliament, by the same minority leader we are talking about when he was majority leader. When the Kwesen case came up, remember that one of the reasons he raised in parliament as deputy majority leader then to prevent the Honorable Kwesen from voting was to the effect that the court processes had already been served on parliament. And they did not have any copies of a stay of execution or any judgment of another court that sought to stay the High Court orders against the Honorable J.T. Kwesen.
Okay.
And the Clerk of Parliament...
It didn't hold.
Please. It did. The Clerk of Parliament, maybe you didn't follow, and that's the problem with the NPP. The Clerk of Parliament actually informed the entire nation that he had before himself the court order, the High Court order, and no other court processes. And as far as he was concerned, he was meant to respect that High Court order. And that resulted in the Honorable J.T. Kwesen not taking part in the decision as to who became the parliament of that parliament, Speaker of that parliament. These were the arguments of Afenyo-Markin. And so we are simply saying that in conformity with that precedent, to the extent that the High Court of Tamale, the ruling has also been forwarded to Parliament, and the clerk has received same, Parliament can proceed to prevent the said Nyindam from continuing to be or act as a member of Parliament for the Kpandai. That is the precedent, MFA. Okay. And you see, again, it was not for nothing I gave you the Ayawaso West Wagon precedents and a host of others. In terms of what the precedent has been when it comes to our electoral laws, are we suggesting that parliamentary candidates and citizens of this country do not have the right, under Article 99 of our Constitution, to demand that election results be nullified? Our Constitution does not frown upon nullification of election results. Absolutely not. Where the court is of the opinion that those results ought to be nullified, it will be nullified. So this argument of my brother Zato,
I'm coming
to the effect that because if you look at the relief sought, they said 42 constituencies. It is not for nothing. Even when you have your release, you say in the alternate, you can even say or any other order the court may deem fit.
Okay.
because you appreciate the discretionary power of the court in such matters. So you can actually go to court and be arguing for 41 constituencies to be annulled. And the court, based on evidence that will be presented to them and the laws of the land, will come to a conclusion that, look, the integrity of that whole process has been compromised. And so we would not just declare that go and rerun in 41 constituencies, but rerun in the entire constituency to ensure integrity of the democratic process. The courts are clothed with that legal authority to do so. And if a judge should exercise that discretionary power in reaching a judgment, it would be absurd for you to refer not just to that judge, but the entire judiciary as being paymasters of a system. And these are some of the issues we are talking about.
Does the Speaker have any role to play in whether or not Yindam stays in Parliament or not?
The Speaker's role is limited, indeed, per the case Afenyo-Markin filed and got the Supreme Court to convene in a matter of 2 hours.
2 hours.
Have you forgotten that a restriction was placed on the Speaker's ability to even declare some people as being, what's the name? Seats has been vacant or otherwise.
For this 2 hours matter, why is Afenyo-Markin the one case in point?
But because I think that Afenyo-Markin who addressed the press conference.
I agree, but
and sought to question the very judiciary that he sought protection from in the not too distant past.
So why aren't we questioning the judiciary but him? Because he went to court if the judiciary agreed to sit in the matter of 2 hours.
No. But see, he is talking about control. If there's anything palpable of perceived control, it was that experience. It was that experience, especially when there are allegations to the effect that he even has businesses and he's related to the former Chief Justice.
Is he? This is news to me.
Absolutely.
Sorry has made those allegations.
And you see, MFA, let me go. Let me respond to you. You said you give me time to respond. You see, please. My reference. No, I beg you. No.
Hamza
I didn't do that.
He did it last week.
Don't do that.
He's doing it again.
Oh, don't do that.
He's doing it before he realizes he will have more time to talk than anybody. He did it last week.
Today,
We all kept quiet. So we are watching the time. I was on the time.
Okay.
So he did it last week. Last week he did this.
MFA, are you the host
this
of the show?
Giving them more time.
Exactly.
Let me put some clarity on this table here. Okay. It is quite just natural that when there is a sitting government, you require more answers from them, accountability. I don't know if you understand me.
Accusing Afenyo-Markin.
No, I'm not saying that. I'm not saying that.
Accusing Afenyo-Markin.
No, I'm not saying specifically. No, I'm not saying specifically to that. No, Kamal, come along.
No, if you make this point,
I am not saying that specifically.
So what is using the time for?
I have a lot of things to actually even discuss. I need the time more than all four of you here. I definitely need the time more than four of you.
We are wasting that.
But Hamza, be civil in the timing.
Oh, but I have been. I've just spoken for less than 3 minutes.
No, you haven't.
Please, no, for 3 minutes now.
You just make the point.
I'm looking, because of them, I'm timing myself.
I'm the timekeeper.
That's why I brought my phone closer. Because of them.
Make the point.
You see, MFA, my brother also made references to a condemnation I made of a judgment of a high court, which is not in dispute. I criticized the decision of the judge. I did not attack the judiciary of the Republic of Ghana. Please, wait.
I said you had cause to chastise the judgment.
Oh, are you going to say you
attacked me?
So this is the thing.
No, I didn't say so.
He did say
I only said
what he said is true.
By their way.
What he said is
You
true.
know where I'm going. So you see what he does, and you accuse me of taking so much.
No, but it's his word against
He made
Your response must be situated in what he said. So please make the point. Kamal, your point is clear.
He made references to the effect that I accused a judge. I criticized a judgment.
Yes.
I am telling him and this platform that there is absolutely nothing wrong with criticizing judgments. It is part of our legal jurisprudence. Exactly. But you cannot compare what I said to a minority leader of Ghana's third arm of government, the legislature, attacking the foundation of our judiciary. That is not criticism. Calling the judiciary and labeling them as paymasters, not one judge, and not the judgment of the Tamale High Court. The foundation of our judicial architecture. And you want to compare the two? Are you okay to compare these two?
No, withdraw that. Are you okay? Of course, he was saying when
No, that's okay. No, allow him. Let him use whatever words he wants to.
You see, let us be.
I have so much.
Let us, please. Let us be measured in our defense of our political parties. To be honest with you, because this was disappointing to say the least. I will not mount any political platform and attack the foundation of a judicial architecture of this country simply because a judge seated in central region or northern region has made a judgment that I disagree. I would disagree.
Okay.
On that particular judgment.
Hamza, I think
criticize him. But you see, in his case, what he has forgotten, and that's the difference between the NDC
Please land
and the
on that point.
What he has forgotten is that even those criticisms inure to the benefit of their own party as a political party.
I've not said so. Oh, come
on. That is the principle, and that is the fundamental difference between the National Democratic Congress and the NPP.
Please land
because
on that.
I could have defended that judgment, and I would have had legal basis to defend same.
Okay.
But we are running a system that prides our rules and laws more than our own parochial partisan interests. And that is what is expected of a minority leader worth his salt. We have seen minority leaders in this country. Never have we had the likes of Afenyo-Markin.
Kamal,
an erratic leader who doesn't show that leadership acumen.
So that's fine.
I'm not done, but MFA decided to cut me. So.
No, you've landed.
Okay?
You have made the point is quite clear.
I hope you are also okay. That's good.
And he also made references to the judge didn't give a full reading.
You see,
and you are a lawyer. And you know that many of these things, it happens. Mostly, the full judgment would follow after the initial the open court judgment.
Okay.
Come on.
Oh, MFA. You see, what is the discussion here? The discussion has to do with whether or not we have a turbulent judiciary, given the trends in the past, now, and future.
That's the secondary. The primary one is the...
It's not a topic.
With all respect, it's a topic.
That's a secondary. Listen, okay. Make the point.
I sat here and I said that. You see, the claim is that Afenyo-Markin made some pronouncements purported to be against judges.
Is it purported? You had them. You had them. Would you like us to bring the tape back?
I am saying.
Please play the tape for all of us to be on the same tape.
Afenyo-Markin made some statements. You see, let me also flow. Made some statements purported to be against
judges. To flow and force.
And I sat down to say something. Look, in this country, and I'm repeating myself so that at least the public, even if here I am not giving a fair judgment, the public listening to me will give a fair judgment. We have had Muntie 3 case against judges. We have had unanimous FC, pointed at judges. We sit here. We have had candidates of election saying that judges were more MPP judges and that when they come, there should be NDC judges for a balance. We have said this here. And I'm saying if it goes back and forth this way, the MPP does this, the NDC does this, we the political actors, at what point do we have to realize that the only forum we can seek proper remedy is the judiciary? This is the argument I am making. So I'm not saying that one A is at fault, B is at fault. What we ought to do and must understand is that our judiciary sanctity must be preserved by us all.
In very simple terms, what are you saying?
Advice or minority leader.
In very simple terms.
What are you saying?
I like this question.
Because it's important.
No, both of you.
No, go ahead.
Both of you.
Go ahead.
Both of you. Kamal has been so far the only person who has brought both political parties to this table, saying that as political actors, we must recognize that the courts are the safest place.
And we should be measured by what we say.
So was he measured?
All of us, listen.
Was the leader measured?
It means this, no, you can't answer the question.
You see, in the case of Afenyo-Markin, then I made a point. Lawyers, that is where I brought him in. I said lawyers by their nature speak to judgments.
Hang on.
And either criticize the judgment or otherwise.
Lawyers
no,
by their nature.
It's important to tell me what the otherwise is.
I'm saying that, look, the context Afenyo-Markin spoke had to do with a judgment of a high court in Tamale.
Yeah.
And I'm saying lawyers by their nature, they speak to judgments. And when they speak to judgments, obviously, you either see them critiquing it or maybe affirming what the judge has said.
Which one did he do yesterday?
And what Afenyo-Markin was doing
yesterday
clearly was to speak to the judgment of the judge at the High Court of Tamale. That's exactly what he did.
Well, I'm going to have to call my producer to play that video for us if we find it. Because
and then by extension, he said that, look, if we are having this trend based on whatever he feels was actually wrong with the judgment, and if by this is the way the contact is going to be, then the judiciary, we should be careful.
Former Consular General.
That's basically what it is.
To Saudi Arabia.
Don't my brother. It's not propaganda. Why? What point are you making?
Okay.
So we're going to analyze you. So you understand that.
I'm not analyzing.
Pull that video.
Now you put that on notice and then ask whether
no, but it answers the question. It answers the question. It answers the question because then you have put both political, you've taken both political parties to the laundry. You have answered the question. And it suffices. Kamal, it suffices because you send both political parties to the laundry. Let me just take your final also submission on this one. I'll come to you then.
You've been trying to
stated that this political party is not behaving well, and by extension, his leader is not behaving well. I think it settles the matter. When I started my...
What do you mean by he's not
behaving well? Afenyo was leading the MPP into the RBC. By the way, in RBC,
you can't say that.
His commentary this morning,
even you with that 1,000,
that is why he finally ended up by saying that both they and the NDC are not behaving properly.
Yeah.
You understand?
Yeah.
And we all listened to the tape. Afenyo was not attacking any judgment because he himself said that he had not seen the judgment and that he was very surprised that a judge giving such consequential orders, calling for a rerun, will not make the judgment available. So based on what was he making all those statements? Based on what? Based on we have also stated, I have told you this morning that the judge that sat on the matter was assigned to this case under the ESWA or the removed Chief Justice Tokonu, under whose watch Afenyo could go to court on Friday, 12 o'clock. By 3 o'clock, he has a judgment.
Okay.
Under the same dispensation this year.
You made those submissions earlier.
Yeah, you see?
No, but you made those submissions earlier.
Kofi Baboni, you see, when one nut is destroying everything, let us hit there, so that the people will understand it.
The viewers are very discerning. They know this.
Look.
They know this. Let me come to this. Because you've made that point.
I'm hard pressed with time, man.
Yeah, no, I'm not hard pressed with time or for time.
No.
Yeah, I just think you have made the points. Dr. Joshua, that's if you can.
Yes.
We have to go to OSP.
Thank you very much. This morning, I like the fact that I'm not the destructive one. Usually, I am. I'm not.
You forgot to add the validated payments of contractors, which is not also
the point I'm trying to
by all ministries.
But why didn't your government...
The point I'm trying to make, they have not paid. Ultimately, look.
It's not part of my discussion today.
If you look at both political parties...
When they have fake papers...
I know that some
engaged in activities...
have been and some are...
Tell them to keep quiet so that you make your point. I have given you the power to tell them to keep quiet.
No, he should tell his colleague MPP man to keep quiet.
If you look at both political parties, they have both engaged in activities that seek to undermine the judiciary. It just depends upon where you are. Usually what you see depends on where you are standing. And mostly, there's a troubling situation we look. Every opposition party, and especially opposition MPs in parliament, have never trusted the judiciary and have done everything to undermine the judiciary. And it's just, when the tables flip, you will see it. If you just compare the last minority or the largest ones, we've seen them pile at the courts. We've seen minorities march to the courts to put political pressure on judges hearing cases. We've seen that happen. The last time, in 2024, we've seen that happen. Flip-flop it, this year, we've seen that happen again. The same minorities, but now where they are sitting, going in. We've never seen the majority in parliament, march up to Parliament House to support a member who has been doing it. No, we've never seen that. So if I ask you, why is it? What compels the minorities in parliament to feel the need to literally march sometimes to the Supreme Court, to the Courts of Appeal, to support their members, when they know that the members are not lacking? They have judges, lawyers, some of the best lawyers to help them. They have everything. That must be troubling to Ghanaians. All those of us that are claiming we love democracy, that must be troubling. What compels, what pushes, what makes minority members of parliament feel the need to physically move to the judiciaries to try to support their colleagues? Because unless and until we do that, we are going to have this cycle that might is right. that all of a sudden, the moment you become majority, you are okay, you know that, okay, the judiciary will take care of you. But at the moment you are a minority, they won't take care of you. If we allow that to continue to persist, it is one of the things that is eroding this. So I hope that the parliament itself can say that, look, let's adopt a policy or reason whereby no members of parliament will have the need to go to the judiciary to try to put unnecessary or undue political pressure on the judiciary when a case is before them. It doesn't matter whom the person is, whether it's your minority leader or what it is. That we should do, because unless and until we do that, we are the same people who now go out there and now we are treating the judiciary like an orphan. If they bath, we say they are wasting water. If they don't bath, we say they stink. So we go there trying to put pressure on them to rule in our way. If they don't rule in our way, then we say they are biased. If they rule in our way, that person they are biased. People must begin to see this as important and serious, and we must begin to say that let's not put undue political pressure on the judiciary to do what we want.
Okay.
When we do that, it is important. And I also want to believe that on such important cases, like these consequential ones, is it not possible for the judge to say that, look, I won't make the judgment until my ruling is final? Can they do that? Precisely because of the magnitude of the case.
No, I think that is very normal that they write the full ruling a bit later.
I'm saying it's not, but what I'm saying is that this case, what is released is just about one page, but the full ruling will come later.
Yes, the reasoning behind the ruling.
So my argument is it not possible for the judge, because the judge has a time on when to rule on the case, right? Can he say that, I won't just issue a one-page and then bring my reason later?
If the one page works, what's the point for the 1,000 pages?
Good. That is because in cases like the political cases like this, consequential cases like this, cases that sometimes tinker on the emotions of people in political.
But you were here telling me that many people in Kpandai, they stood in the sun, the rain, and everything, and that so there must be clarity. We must proceed.
My point is that, couldn't the judge have waited to have both the full reason ready and released it?
It is as if we give the power to the judge and we still want to direct how they want to. I'm just saying that.
If,
couldn't have. Anyway.
How long? Let's say it's going to take 1 week to come out with the full judgment. Couldn't he have waited for that 1 week, then release all of it?
Time value of money. Time value of money.
So anyway, do that, then by now, we wouldn't be guessing. We would have the whole reason.
Let's make progress and talk about the OSB.
So for me, on such things, those are some of the reforms I hope that the new Chief Justice will bring. To say that, look, when the case is that, and we've seen that happen throughout, even the appeal condition, they say, we'll come late. I'm like, well, you have all the time to issue. Why don't you just wait, if it's another week or two, and just come up with the whole judgment and the reason behind it. Okay. Instead of you giving us one, and then we come, we do this commentary, we do this, then finally the other one comes, then we start another commentary again.
No, but you're worried about the commentary? In fact, the courts are happy when you don't comment on it.
So they just bring us one, so that we just do our talking and then go. Let us talk again and again.
If that's the reason, then we'll
let's talk about OSP. The courts are doing a party and the after party. They are doing a party and the after party. All I'm saying, let's just...
You want to have one party?
One big one.
I see.
Yeah.